Well, this can certainly be important this time of year with ice and snow out there. If you own property, you're legally required to protect guests from dangerous conditions, albeit a dog leash, ice, you name it. Tom Sinas here to discuss your legal obligations out there.
Well, this is a tricky area of law that lawyers and judges refer to as premises liability.
Okay.
And you would be surprised at the number of calls that an office like ours gets from people who have been hurt because of something that happened at someone else's house or in someone's front yard. And I think a lot of times people don't, and I wouldn't expect them to, don't understand the very kind of complicated rules that can apply to these kinds of cases.
Okay.
That is, just because you're hurt on someone else's property doesn't mean you have a legal claim against them, right? So when do you, or when might you? Well, the basic rule here is that a property owner has a duty to protect people from dangerous conditions on the land. They have to exercise a duty of reasonable care. And that duty really only extends to those things that the property owner knows about.
Right.
In the law, we call having notice of something.
There you go.
You know, it's kind of hard to protect someone against something that you don't know
Sure.
about. So the duty here is one of reasonable care against dangerous conditions that you know about.
Okay.
Okay, so that's the basics. One thing that people don't know, unfortunately, until maybe they call a law firm like ours, is that in Michigan, we have a very tricky rule called the open and obvious rule. And the open and obvious rule can be a very difficult defense to overcome for people who have been hurt at another person's property. And what it basically says is that if the condition that you were hurt by was open and obvious, meaning obvious to a person, as the law says, of ordinary intelligence,
Out in the open for everybody to see, essentially.
then that is a defense that the property owner has.
Sure.
This is a bit ironic because if it was so open and so obvious, then presumably the person wouldn't have fallen over it or been hurt by it.
Sure. Oh, yeah, I see your point there. Right.
Right? But it's a very difficult defense and one that can be very hard to overcome. There's a different standard that applies to landlords and people who are under a lease. In those particular cases, landlords have a special duty under statutes to do two things. They have to make sure that the common areas are fit for their intended use, and they have to keep the premises in reasonable repair. Now, again, over time, our courts have said here, the standard is not perfect, right? Reasonable repair doesn't necessarily mean perfect repair. Fit for an intended use doesn't mean it's perfect use. But again, if you are involved in an incident as a tenant, then you have a different set of legal rules that would apply than if you were involved in an incident where, say, you went over to someone's house and were hurt there. So to sum up here, the law in this area is not easy. There are a number of hurdles that have to be overcome, a number of issues that have to be analyzed. I hope at this time of year that nobody ends up having to call our office to raise a question about this, but it's more often popular this time of year than not because people just tend to get hurt more often.
A lot of gray area, I can see you guys could really help out. Where do people track you down?
They can find us online at www.sinusdramus.com. Give us an email at info@sinusdramus.com or call us in West Michigan at 616-301-3333.
Thanks, Tom.
Thanks, Derek.